Today I'm going to give you a brief overview of local policy updates included in Update 115 from TASB. As a reminder, legal updates do not require board approval as they are state laws and/or mandates. Local policy is approved by local school boards. In this brief overview, we will review the following local policy changes: BF, DIA, EI, FD, FEB, FFG, FFH, FNG, and GF. I'm going to begin with the new federal Title IX regulations from the Department of Education that go into effect on August 14, 2020. There are substantial revisions recommended to both DIA local and FFH local to comply with new federal regulations. The most significant change addresses the development of the district's Title IX formal complaint process and the standard of evidence the district will use to determine responsibility in a Title IX formal complaint. Other changes address the process of reporting prohibited conduct and revise the definition of sexual harassment to align with the federal regulations. DIA local has also been revised to incorporate the recent United States Supreme Court decision, which held that an adverse employment action against an employee on the basis of homosexuality or transgender status violates Title VII's prohibition on sex discrimination in employment. As a result, the policy clarifies that discrimination on the basis of sex includes discrimination on the basis of biological sex, gender identity, sexual orientation, gender stereotypes, or any other prohibited basis related to sex. BF Local is your policy on policies. The revision to this policy reinforces the practice that legal policies are not adopted by the board. They serve as legally referenced material to provide information on existing law and, in some cases, context for your district's local policies. It's important to always read the legal and local policies for the same code together. Revisions to administrative code rules have prompted several changes to policy EI local. First, the provisions on partial credit reflect a change in terminology in the rules. Instead of referencing the award of credit per semester, the district is permitted to award credit proportionally when a student receives a passing grade in half of a course. Another change addresses the method by which the student earns credit for failing part of a course. Policy text requiring the student to retake the portion of the course with the failing grade has been deleted. The removal of this provision provides administrators flexibility in selecting the most appropriate method for a student to earn credit for the failed part of the course. Required policy provisions on transition assistance will now be in FD local. As mentioned in our discussions on EI local, TASB is recommending new provisions at FD local to meet the local policy requirement from the administrative code rules on transition assistance for highly mobile students who are homeless or in substitute care. The policy must address awarding credit earned prior to the student enrolling in or transferring to the district. Policy FEB local provides information on attendance accounting. Administrative code rules were amended to delete a reference to taking attendance during the second or fifth instructional hour. Now the district can determine its official attendance taking time. The recommended policy text assigns to the superintendent the responsibility to designate this attendance taking period. There's not a requirement to include the official attendance taking time in board policy. It may be designated in administrative procedures. Significant revisions have been made to this local policy on child abuse and neglect to comply with the amended administrative code rules. Recommended text addresses sexual abuse, trafficking, and the maltreatment of children. This information must also be included in the student handbook and in the district's improvement plan. To ensure that all policy elements are addressed in the board-adopted FFG local, we've moved provisions from FFG exhibit to the local policy. The exhibit will be deleted. FNG local and GF local address the issue of grievances for students and parents and for the public. The recommended revision specifies that an individual who files a complaint after being ejected or removed from district property is entitled to address the board within 90 calendar days rather than business days if the complaint is not resolved at the administrative level. And that brings us to the end of Update 115 overview. Please let me know if you have any questions.